Another day, another solution. Let's talk dirt. For years, during and after the mortgage crisis, homeowner after homeowner walked into court. They weren't looking for a handout, they weren't looking for a loophole, they were looking for answers. We're not talking about dozens, we're talking about tens of thousands of Texans, Americans. They were seeking answers about who owned their loan, answers about why foreclosure had started in the first place, paperwork that didn't make sense. In other words, they walked into court seeking basic fairness, and they lost, and we all lost. Not because the law was settled, not because the paperwork was clean, but because asking hard questions became inconvenient. Many of them were told the same thing over and over and over. They're just trying to get a free house. The worst part about it is that story stuck. It was easy, it was convenient, but it was devastatingly wrong, and we're still facing the consequences today. So let's dig into this further. Most of these homeowners didn't wake up and decide to sue a bank. Lawsuits are expensive and uncomfortable. They walked into a court because foreclosure had already started. It wasn't threatened, it was real and already in progress. They received notices they didn't understand. They were told their loan had been transferred, sometimes multiple times, often without explanation. They were told not to worry as they were under loan modification reviews, while in reality, they were already in the process of losing their home. These homeowners asked basic questions. Who owns my loan? Who am I supposed to pay? Why is this entity foreclosing when I've never heard of them? And the answers, if they got any at all, didn't add up. That's when lawyers got involved. Not to stop paying, not to game the system, but to slow things down. Only long enough to verify who actually had the legal right to take the homeowner's house. See, once foreclosure starts, court isn't a choice, it's the only place left to go. And yet, those cases were brushed off. Bank attorneys would often say they just want a free house. But see, that never fit reality because most of these homeowners weren't asking for a windfall. They weren't asking for loopholes. They weren't asking for bailouts. They were pointing to paperwork that didn't make sense. Assignments signed years later, sometimes after the foreclosure had already begun. Notes transferred multiple times through entities that barely existed on paper. Foreclosures by banks that had been closed for years, signatures that didn't line up, chains of title with missing links. We also saw fraudulent notary stamps. They weren't asking the system to give them something, they were asking for fairness. In a system that had just bailed out major banks to the tune of trillions without a single request back from those banks, while American taxpayers picked up the bill. And underneath all of it was the same request, not a trick, not a theory, not a stunt. Just follow the Supreme Court precedent. And I want to emphasize here because this part gets glossed over. I personally represented many of these homeowners, not one or two, hundreds. I reviewed their files. I traced assignments. I followed chains of title. So when people say these cases were just about free houses, that wasn't just wrong. It was offensive and damaging to America because it completely ignored the work of honest, hardworking attorneys who were doing their jobs. They were just trying to keep the system honest. Most lawyers, they don't build a practice around fake arguments. I certainly didn't. No case survives without real world work behind it. Reducing all of that to they want a free house, it was easier. It was easier than engaging and resolving the real issues. And most importantly, it was masking the real issue. Many of the banks didn't even own the rights to the home they were foreclosing. And here's where things get really absurd. In some cases, it is literally harder to repossess someone's financed washing machine than it is to take their home. Let that sit for a minute. To repossess a washing machine, a creditor usually has to prove that they own the debt, they have to show a valid security interest, and they have to follow notice requirements. If they miss a step, the entire repossession fails. But during and after the mortgage crisis, homes, the most significant asset most people will ever own, they were taken without requiring the same level of proof. Ownership of the debt suddenly didn't matter. Asking for proof was treated like gamesmanship. Now, to me, that's backwards. If the law demands precision before you take a washing machine, it should demand at least that much before you take someone's home. To understand how we got here, you have to understand what foreclosure used to mean. Historically, a foreclosure was the enforcement of a debt. That debt was proven by the promissory note. The mortgage or the deed of trust that existed only to enforce the debt non judicially, meaning outside of court. That's why we call the mortgage and the deed of trust today the power of sale. The debt came first, the power came second. That wasn't controversial, that was the law. It was straightforward and it was simple. In 1872, the U.S. Supreme Court decided Longan v. Carpenter, and the court was unequivocal, not implied, not suggested. Here's what the court said, and this is a direct quote: "The note and mortgage are inseparable, the former as essential, the latter as an incident. An assignment of the note carries the mortgage with it, while an assignment of the latter alone is a nullity." The assignment of the latter alone is a nullity. What does that mean in plain English? That means that you can't separate the note and the deed of trust. Those are the court's words, not mine, not a theory, not a blog post. Meaning this: you do not get the power unless you own the debt. That wasn't a loophole. That was and still is United States Supreme Court precedent. But during the mortgage crisis, that framework changed for some reason. Texas courts and the Fifth Circuit in particular, they began treating foreclosure as an enforcement of a power, not enforcement of a debt. Under that approach, the note was an asset that could be the subject of a lawsuit, and separately, the mortgage could be pursued by a completely different bank through foreclosure. In other words, we can now separate the debt and the mortgage. If you're confused, that's the point. They literally allowed the exact opposite of the US Supreme Court law, and more importantly, common sense. Now, all of a sudden, servicing authority was enough. Assignments were brushed aside. Borrowers were told they lacked standing to even challenge the assignment and the foreclosure. That's not an interpretation of Longan, that's a departure from it. During the mortgage crisis, courts were overwhelmed, dockets were flooded, speed replaced precision. And once that shift happened, it hardened. Despite thousands of cases raising the same issue, the US Supreme Court never heard a case to clarify the law. When the same question keeps coming up, silence becomes a decision. In this video, I focused on the history, what Supreme Court precedent says, what Texas law came to say instead, and how that shift played out during the mortgage crisis into today. In the next video, I'm going to go further. I'm going to explain my personal view, based on litigating many mortgage cases, about why this shift happened and who it ultimately benefited. That second video is opinion, this one is foundation. If you found this video informative, please subscribe to our channel and hit the like button below. Remember, this video is not legal advice, it's educational. It's meant to help you understand the issues and ask better questions about your own situation. If this is something you're dealing with, make sure and speak to a lawyer who understands this area of law. You can find more at www.garadays.com or in the links below. As always, thank you for watching.